If it don't fit, you must quit.
So today was day 3 of the William Polo Edwards trial, and the defense did go ahead and wrap up their day. So let's get started talking about that. So the defense wanted to bring in a Mr. Pickett. They did state that they tried to send him a subpoena. He never responded, so they were unable to get him to come in. And they wanted to see if they can just present the information he presented in the previous trial. But the state objected, and they did a sidebar, and the judge determined that they had plenty of time to try and get him in. And she did state that with the states kind of referencing back to the experience that they had, that she stated that she really should not have allowed him to present the information he presented in the previous trial after she heard it. And she was referencing back and thinking, I probably should not have let that in. It was unfortunately too late. So I didn't, state scratch it from the record. I just moved on. But now that I'm referencing back to that memory, I'm going to go ahead and sustain the objection. So she sustained the objection that the state made to allow any of the information he presented in the previous trial to be presented in this current trial.
I do recall the court recalls all of that now. And looking at this, I couldn't really quite remember. But when you mentioned that about the email, it did cause me to remember and to remember testimony. And let me say this. I should have, the court in the prior trial should have requested a proffer before the detective testified. Because had I obtained a proffer of his testimony, I would have rejected it. Because after hearing it during the trial, I believe that I was in error to allow it. Now, it was an error that would have favored the defense in that case, so it would have been reversible. But it wasn't, but after listening to it, it was not admissible. But the court had already granted him permission to admit. I could not, the way lead counsel explained the situation in the state, it was not clear to the court. So the court made the decision to err on the side of caution, allow the defense to allow the detective to testify. But then after hearing it, I remember noting to myself that I should have excluded that witness. The problem with that situation was that his prior counsel had not found any sufficient motions or notices about any witnesses for the court to be able to address those issues prior to the trial, and we were in the midst of the trial, which is why this court's, I'm so strenuous about trying to clear up those issues so that while we're in the proceeding, the court doesn't have to then try to figure out those issues. So I can tell you that I would not maintain the same ruling in this case, especially after I heard it all. But it had been admitted. There was nothing the court could do about it because it was already in front of the jury, and I was not going to try to undermine the integrity of the evidence that was presented. But I will tell you that I do recall that and realized I really, in my opinion, had made a serious error in allowing that testimony in the defense case in chief. Mr. Piper is the person that needs to testify about that because he,
I understand, but I would like it just noted that I got my subpoenas issued and served.
That's no error on your part, counsel. I do understand that that is not the issue. However, the state does have information on the location of Mr. Piper. I would ask the investigator to provide you all that information. And so you can make an effort to contact him before you close today. I'm not going to keep holding up stuff waiting for him, but I will give you an opportunity to do that.
So the first witness that they actually ended up calling today was a Detective Mitchell, and he was kind of in reference to the previous witness they wanted to bring in that they couldn't, and his kind of purpose was to go over some surveillance video, but because that previous testimony was not allowed in any way, shape, or form, his only purpose was to say, did you obtain that surveillance from him? Yes, I did. And that was pretty much it. And he was off of the stand. Now, the second witness of the day was attorney Dennis Sweet. He was the original attorney that Mr. Edwards reached out to when he was originally notified that he was, a possible suspect in this incident. And so he kind of goes over the experience that they had.
Can you state for the men and women of the jury your full name, sir?
My name is Dennis Charles Sweet III.
How long you been practicing law?
Over 42 years.
And on May the 1st, 2022, Attorney Sweet, you received a phone call from me, correct?
I don't remember the exact date, but it sounds right that time I got a call from you.
Yes, sir. And I was calling you about the current situation that they were saying had transpired. Is that correct?
Right, I think I was in a trial,
Correct.
and you called me about turning yourself in. You said you had understood that someone had made allegations against you,
Correct.
and that you wanted to turn yourself in. And I said, okay. I couldn't help you right then, because I think I was in a trial.
That's correct.
In trial up there, they had moved me up to Aberdeen, so I was not available to do here. It was a serious trial, and I had to focus on that, and couldn't help you.
Yeah. And in the course of our conversation, I think we had several conversations, and I was imperative about getting you to get me turned in, correct?
You were. I told you, I said, man, you don't need to be out here and just get arrested. You said, but I don't want to get turned in without you. I want you to turn me in. I said, you're going to have to wait, because I can't focus on anything but the trial again. It was so serious, too. And I said, could I arrange with somebody? He said, no, I want you to turn me in. I just trust you. And I said, okay. I said, well, be safe. He said, well, I'm going to wait on you to turn me in.
Exactly.
Yes.
And you didn't give me any directions about leaving or hiding or anything like that, correct?
No, I did not.
You just told me to just sit still and try to wait on someone from your office to
Yes.
see if they can do it for me, correct?
Right, I told you.
Meaning, please, you don't direct, you do not leave.
I don't remember all specifics, but basically, right, I don't tell anybody to hide. I just told you what I couldn't do. And I told you to be safe, and, because they were looking for you. You don't want to get harmed. But I wanted you to turn yourself in. You said you wanted to. You just wanted me to do it.
And at any time after that conversation, did I reach back out to you any other time after that?
I think you may have tried or did. I'm really so long ago, I really don't remember. I know that you contacted me more than once, I think, about turning yourself in.
And that's the totality of your involvement in this case, correct?
Right. After that, you contacted me, but I had a conflict, and I told you, I said, look, when it came to representation, I think I recommended you previous counsel.
Yes, sir.
I said, look, I can't do it.
What's the conflict again?
Yeah.
So the third witness that the state presented was Dr. Amy Malone, and she's a forensic serologist. Please forgive me if I'm saying that wrong, but she pretty much studies the bodily fluids of the body. She's an expert in that. Like, he went through the whole process of, going through her history, and he started to ask her about some of the evidence that was presented in the previous trial, and then the state objected to it, and they did a complete sidebar, and it was determined that because there was not a foundation of her information being presented, like the documentation she was going to go over, there was not a foundational presentation of that information, and that needed to be taken place, or any testimony that she was going to provide was not going to be allowed because they didn't establish the foundation, and they would have to brought in additional witnesses to do that foundational information, and they did not do so, and she was not going to allow additional time for them to call the people in to do additional foundational steps. So her testimony was pretty much null and void. She was off of the stand. Now, the fourth witness that they were going to present was a David Whitehead. And again, they did another sidebar. What the issue was with him, I am not sure, because they completely didn't come back and say anything about that, and the defense rested their case at that time. So they went ahead and released the jury for a little bit so they can go over their jury instructions. They did their hearing on the jury instructions, and then they did closing arguments. So we're going to go ahead and take a listen to some of those closing arguments from the state and the defense.
You see the authentications of these records that have come in through AT&T and Verizon. You heard the testimony. They can't be altered. They can't be manipulated. They can't be changed. They just show data points of locations. All of that's important because we have an eyewitness that saw him pull up, no one else in the car. She tells her friend about it. She goes back to her room, and then she hears smoke comes out. She told you she saw the sparking from the hallway, hitting the door, hitting the ground, whatever it was that's hitting. She sees her friend lying there, bleeding out. And this man, this defendant, William Edwards, standing over him, she sees that with her eyes. He turns, he walks away, gets in a black truck. She describes light colored pants, white pants, dark colored shirt. They picked him up in New Orleans. dark blue shirt, light pants, light coat. So what it is we have an eyewitness testimony of what happened. And then we built every corroborating piece of the puzzle to show you why what she told you was accurate.
I told you that most people hate the truth. I told you that there were lies that got us to this point. Also, he reminded you of some great leaders of faith and truth leaders. I told you about Nelson Mandela and his 28 years of suffering in an African prison because he spoke the truth. I told you about Dr. Martin Luther King because he spoke about the atrocities that happened to colored people in America. They don't want it. Truth is all that this started with a lie. That's true. All of this started with a lie. You heard testimony yesterday from Detective Anthony Fox and Detective Kenneth Burnett that said that when they first interviewed Shadow Robinson, after reading her Miranda rights, she told them that Bobby Carlton Davis, standing over him 2 times, but you heard the medical exam, he was 3 to 4 feet away. But then you heard Shadow Robinson get on the stand and say she did not see me shoot Bobby Carlton Davis. What's the truth? We don't know, because Shadow Robinson lied. You remember I told you about the toothpaste, right? I told you that lies are like toothpaste out of this tube. Once you squeeze this toothpaste out of this tube, ladies and gentlemen, it's literally impossible to put it back in here. And when Shadow Robinson told that lie on May 1st, 2022 to those detectives, she couldn't put it back in. You heard Detective Burnett and Ms. Robinson, Detective Burnett and Detective Fox talk about Bobby Davis' phone. They asked Ms. Robinson, do you have his phone? She lied. She said, no, I don't have it. But what Ms. Robinson didn't know is that Bobby Davis' family loved him. Bobby Davis' family had been telling him for months, leave Shadow Robinson alone. She's bad for it.
Objection, Your Honor. The fact's not evidence.
Facts not evidence, second warning.
Think about it, ladies and gentlemen. Every time we try to present the truth, facts will manipulate. Throughout the entire presentation, we rarely object to anything. You know why? Because truth doesn't have to object. It just waits its turn. Remember I told you in my earlier open arguments that truth is like love, it's patient, it's kind, it's generous. It doesn't interject itself, it just waits. It waits on you to find it. It waits on you to seek it. That's what truth does. They have not presented any testimony from Ms. Robinson's adult son. They have not presented any testimony from anyone that states I have a problem with Bobby Davis. They have not presented any testimony that says I even knew Bobby Davis. As long they have not presented you with a weapon. A weapon. They want you to perceive that I have a weapon, but they haven't presented you with one. They haven't presented you with a motive. They haven't presented you with any proof that I even posted anything on social media. If it don't fit, you must quit.
So that is all of day 3. The jury does now have this case, and we are now in verdict watch.